Hello, I'm Patrick West with Patrick West Law Firm. How do we start off the bankruptcy process, you might ask? Well, first we need to evaluate your needs. We need to determine whether you need a bankruptcy. And if so, what type of bankruptcy best suits your situation. That will involve assessing your property and your debts. That assessment will include things like, is there a house involved? Are you current on your house payments? Are there cars involved? Are you current on your car payments? Is the IRS involved? Is the IRS a type of debt that can be discharged in a Chapter 7? We will also determine whether there is a business involved. That can make the planning process all the more important. There are ways that you can keep running your business even in a bankruptcy, but I need to know about it and we need to plan around it. After we determine what chapter is appropriate for you and what chapter of bankruptcy you qualify for, then we're going to need to gather information. The gathering of information is done through a comprehensive, easy-to-use questionnaire that I've developed over the years. It'll give me information about your house. It'll give me information about your cars. It'll give me information about all your personal property. It'll give me information about your debts, your creditors, people you owe money to, your credit cards, your medical bills, tax debts, child support debts, things of that nature. When you fill out that comprehensive questionnaire, you'll drop it back off to us. We will use that information to develop your petition and your schedules and your statements. Those are the documents that have to be filed with the court. Once we prepare those documents, you and I will sit down and we'll go through those documents together, page by page. You'll need to sign off on them as being true and correct, and then we will file your case. Once we file your case, an automatic stay goes into effect in most cases. The automatic stay stops creditors wherever they're at. If they sued you, they have to stop the lawsuit. If they're in collections, they have to stop all collection efforts. If they're in foreclosure, they have to stop the foreclosure of your house. So it's very important that we file the case before any judgment takes place, or any foreclosure takes place, or repossession of vehicles takes place. And that's one thing we'll go over in the evaluation, to determine whether you have an emergency need or not to stop some creditor from taking an action that's going to be adverse to you right away. That's why the initial evaluation is so important, to determine whether you have an immediate need. You have a foreclosure or a repossession, or the taxing authorities are about to levy your accounts, or you have a judgment creditor that's about to try to garnish your wages or garnish your bank accounts, and we will file the petition based on those emergency needs. What happens when you file a bankruptcy petition? In most cases, unless you filed a case immediately preceding that got dismissed for some reason, an automatic stay will go into immediate effect the second that case is filed. That automatic stay will stop the foreclosure of your home. It will stop any repossession of the vehicles. It will stop creditors from harassing you. It will stop a lawsuit from moving forward. And it will allow you some breathing room so that you can resolve those issues through your Chapter 13 or Chapter 7 bankruptcy. What's the next step after we file the petition? The next step will, after we file the petition, approximately 30 to 45 days, there will be a meeting of creditors. The meeting of creditors will take place in a Chapter 7 at a downtown location in the Fort Worth Federal Building. Otherwise, if you're in a Chapter 13, it will take place in North Richland Hills at one of the trustees' offices. The meeting of creditors is where creditors can show up and ask questions. They have to be about your bankruptcy or about your financial situation. In the vast majority of cases, creditors do not show up at these meetings, so it's not something you should lose sleep over. In the vast majority of these cases, creditors don't show up for these meetings, so it's nothing you should lose sleep over. At the meeting of creditors, whether it's a Chapter 7 or a Chapter 13, you will be asked questions either by me or by the trustee about your financial situation. It will essentially be an opportunity to just go through your schedules and confirm all the information that you and I have already reviewed together. In a Chapter 13, the trustee is going to use that opportunity to determine whether they need to object to your plan that we've proposed to pay back your creditors. Either the trustee will determine that you're not feasible, that you don't have enough income to make the payments under the plan we've proposed, or they will file an objection saying that you need to pay more money to your unsecured creditors because you have enough disposable income to do that. What the trustee determines at that meeting is not determinative. Only the judge can make that decision. So whatever the trustee determines at that meeting, we can object to their objection and present our case to the court for either not paying more money or that you are indeed able to make your plan payments. In a Chapter 7 341 meeting, you're going to sit down, be sworn in. The trustee or I are going to ask you a set of questions that basically goes through your paperwork and make sure you've listed all of your property and listed all of your debts and that your income and expenses haven't changed materially since the day we filed. That meeting won't last very long. They generally take about 5 or 6 minutes to finish up the meeting. They schedule, every 40 minutes, they schedule 6 or 7 of these meetings, so they don't expect them to last very long. In a Chapter 7, there are going to be reaffirmation agreements with regard to vehicle debts, sometimes with regard to a mortgage debt. That reaffirmation agreement will be signed by you if you want to keep the vehicle, and it will say basically that I agree to keep making the payments under the contract I had with this creditor before I filed the bankruptcy. And if my car gets repossessed a year from now or whatever, it'll be just like I hadn't filed the bankruptcy. They can sell the car at auction and they can come after me for the difference. So reaffirmation is something very important that you have to think about whether you want to reaffirm a car debt or not. In a Chapter 13, there will be a confirmation of the plan process. We will fight to get your plan confirmed, and then we will review all the claims that have been filed by creditors and determine whether those claims are valid or not. You will be involved in each step of this process, and we will work together to get you the best result in your Chapter 13. 60 days after the 341 meeting in a Chapter 7 case, the court will issue a discharge. The discharge discharges you of all debts except for ones that have been reaffirmed, like vehicles, or certain non-dischargeable debts, some types of federal income taxes, or child support, or student loans. None of those debts are dischargeable and may be a reason for you to consider Chapter 13 instead. In a Chapter 13, you get your discharge after the case is completed. That's 3 to 5 years after you file the Chapter 13 case. When you get the discharge, it will discharge you of all debts that haven't been paid. That'll be all of the unsecured debts that you weren't required to pay in the Chapter 13, or all of the, in certain situations, you may be entitled to a hardship discharge. And that's a discharge that's rarely granted, but can be granted in certain circumstances to allow you to discharge debts such as student loans or certain tax debts that aren't otherwise dischargeable. All forms of bankruptcy involve very complicated processes and very complicated decisions with regard to property and being able to maintain your property. It's not something that should be done on your own. Give me a call at 817-332-2600. My staff will be happy to set an appointment for a free consultation, and I will be happy to answer questions at that consultation.